Hi all, I'd like to introduce Natalie Salami of Blockchain University Cohort 1. She's an attorney and she'll be presenting on startup issues facing blockchain and Bitcoin startups.
So, hi everyone. The purpose of this talk is not really to prevent every legal issue you can encounter when you start up a business, but I kind of want to take things that I found common to most Bitcoin and blockchain companies and kind of present them so people are aware of them, they know when to consult an attorney, and can avoid kind of the most, I guess, harrowing of these issues. So we're going to kind of talk about things that we think may pass, things that have already passed, and also kind of learn from a couple of case studies. So kind of learn from other people's mistakes. All right, so these are kind of the things that I'm going to be going over today. The first two are on the top for a reason. Anti-money laundering laws and money transmitter licensing laws are the ones that really have the harshest penalties. So in most cases, these are actually felonies, which means you can go to jail for a year or longer if you don't abide by this. So that's why I put it at the top, and I think that if there is one law you're going to follow, it's going to be these. All right, so the IRS has actually issued rulings on Bitcoin. So this is kind of one of the only things that's actually written in stone, and this is how the IRS handles it. So the IRS issued a ruling in March of 2014, and they said that they consider Bitcoin for IRS purposes to be property. So there's a number of things that kind of result from that. And one thing that I thought was interesting is that they subject Bitcoin miners to self-employment tax. So what that means is you have to pay your own Social Security and Medicare taxes when you mine your own Bitcoin. And usually self-employment tax is done for something where you're actually spending a considerable amount of your time working towards it. But with Bitcoin mining, you just kind of set them up and then they run. So it's kind of a departure from what you would expect. But that's what the IRS said is, you have to pay self-employment taxes if you're running mining rigs. So as property, you have to report your gains, and you kind of take what you either purchased or what you spent on your mining rigs into consideration as the basis, and then you look at the sale price. A lot of people have started reporting when Bitcoin started losing value, because you can report your losses too. So you can actually go back 3 years and correct any of this if you have losses that you haven't reported. And you can save quite a bit of money on that. All right, so a little bit more about the anti-money laundering laws. These laws were really set up to avoid money laundering and kind of a diversion of funds into black markets. So there's terrorism concerns and things like that is why the government has set up such strict regulations around this. There's a public list called OFAC, and that's a list of terrorists around the world. It's basically a list of bad actors that a number of countries have actually joined together to say that these people have acted so badly that they're really cast away from the global economy. So there's a number of countries that will not allow you to do business with any of these individuals. And the list is about, I'd say it's about 600 pages long, just names and addresses. In order to comply with AML Banking Secrecy Act, you're going to need to know your customer. These are the things that you're going to need to know about your customer. And you cannot claim ignorance on these things. So you actually have to ask your customer about their identity and their address. And then you need to know kind of the source of funds and nature of business to monitor their activity and to see if anything looks out of place. So if their transactions don't really fit with the nature of business, then you would actually need to suspend their account and ask them about it. And if they don't really have a good explanation, a legitimate explanation for why those transactions are there, then you would need to kind of submit a suspicious activity report. So suspicious activity reports are the reporting requirements for when you have transactions that don't really fit in with what should be going on and you suspect illegal activity. These things are actually filed all of the time in banks. So I think if you have a transaction over $10,000 and it's a cash transaction, you've had one of these reported on you. So it happens all the time, and a lot of people are really kind of weary of filing these suspicious activity reports on their clients, but these happen all the time, and it's really only a very small percentage that the federal government actually follows up on. They have kind of the people they're already watching when they have these. So Ripple Labs is a kind of famous case. They were sanctioned $700,000 for not abiding by anti-money laundering laws. This was pretty recent. Nobody went to jail, so that actually says that they have a pretty good team when it comes to compliance. Question?
Yeah, well, I was going to say, I mean, you mentioned it's centered around terrorist activity. It's just not that. Drug trafficking, political persons. I mean, there's a whole broad range of, suspect activity besides just terrorism or whatever. So, but it's good for people in the room to know that, so they know what to look out for.
Right. Yeah, it's just all black market stuff.
Yep.
Yeah. So Ripple Labs, the complaint was filed against them. They actually settled the same day with the federal government, and part of their settlement condition was that the California state action against them, which actually included the criminal action against them, was actually dropped as part of the federal settlement. So, it did cost them quite a bit of money, but I don't think it was too bad of a result for them. Another thing with Ripple Labs is that the complaint really alleged things that were done between like 2011 and 2013. So it's actually older violations that they were recently sanctioned for. And I think they have about another 6 months, according to their settlement terms, to up their compliance. All right. So the SEC has not actually issued any specific Bitcoin or blockchain laws. The only thing they've actually publicly issued is an investor alert. So in May of 2014, they issued a letter to consumers basically saying Bitcoin is extremely risky and we don't recommend anybody transact in anything that has to do with Bitcoin. So, us here in this room probably have a different opinion of Bitcoin, and that's why we're here, but that's what the SEC has said about Bitcoin. The SEC has also clearly said that it considers Bitcoin to be equivalent to cash when it comes to investing in companies. So there was a case against Satoshi Dice. Satoshi Dice actually tried to issue equity in one of his companies in Bitcoin. So you could send Bitcoin and you would actually own a part of his endeavors. And there were two. I think Satoshi Dice was one of them, and then he also was issuing shares in another company saying, I'm only issuing in Bitcoin, so I'm not actually issuing equities for cash. But the SEC said it's a cash equivalent in that case, and they did fine him. I think he had to get rid of all of his earnings plus about another 10 or 20,000 in penalties. BTCT.co was exactly the same, except he used both Bitcoin and Litecoin, and they said it's equivalent to cash in that case. The FTC has looked at Bitcoin companies and issued, they've applied their traditional consumer protection laws to Bitcoin companies. So one of the most, prominent examples is Butterfly Labs. Is anybody here familiar with Butterfly Labs? A couple people? Okay, so Butterfly Labs was actually building Bitcoin miners for people and sending them out. And they pre-funded with Bitcoin. So they took a lot of Bitcoin orders, the pre-orders, and they were very, very late shipping these out. The delay in shipping it out is not sufficient for the FTC to go after them, but they actually said that they were using the miners for their own gain before shipping them out. So the industry standard for testing hardware once it's built is about 5 to 10 minutes running, and they actually left these on for up to an hour, it says, which doesn't sound like a lot, but they did earn Bitcoin, which they kept on these miners while they were testing them. So that, combined with all of the consumer complaints and the delays in shipping, led to this case. One thing that's notable about the Butterfly Labs case is a judge actually stayed their operations while they were figuring this out. So these things take years to go through, and they actually had to cease all operations while they waited. So that effectively killed them. There's more than 70 federal consumer protection laws, and they can apply to your company. I've pulled out a couple that I think are actually particularly relevant to Bitcoin companies. The truth in lending, there's a lot of companies that do Bitcoin lending, crowd lending, that type of thing. And Truth in Lending Act is definitely something that they would need to follow. The Dodd-Frank Act is something that my company, Spritzel, is pretty familiar with now. We issue derivatives on blockchain, and so we are definitely dealing with a lot of the Dodd-Frank legislation. The electronic fund transfer regulation, if you have a wallet service, you're probably going to want to make sure you look at that. And then there's the Gramm-Leach-Bliley Act, which deals with your financial privacy. So this is kind of a concern when you're talking about transactions and transaction anonymity and things like that. So this generally goes with your card information, but it's not too much of a stretch for the FTC to say, we think that this is actually economic activity and you need to protect your customers' privacy when it comes to their Bitcoin transactions. You know, they haven't yet done that, but I can kind of see it down the pipeline. You're not required to give a warranty when you have a company, but if you do, you better make sure that those warranties are valid and you can live up to them. The Restore Online Shoppers Confidence Act is actually something that I think is pretty important to all Bitcoin companies. Basically, if you're transacting online, you need to disclose all material facts of the transaction. So this really has to deal with customer transparency, and you probably need to disclose more about your business than other types of companies, especially because you're dealing with Bitcoin and the risks of Bitcoin need to be disclosed. Actually, in the New York Bit license, there is provisions for disclosures, and they have a whole list of things you need to disclose for New York customers, some of which are Bitcoin is extremely risky, you may lose all of your money, things like that. And those need to be clearly displayed to the customer. Children's online privacy, it's pretty self-explanatory. Most people don't allow people under 13 in their terms of service. I recommend that for any company that's dealing online. The US Safe Web Act actually is an act that allows federal investigators to associate and work with international investigators for online commerce. The Unlawful Internet Gambling Enforcement Act, I think, is pretty fun to talk about because one of my favorite use cases for Bitcoin was Satoshi Dice. This was enacted in 2006. Poker Stars, I believe, continued to operate, and they were indicted. There's another company, the name escapes me right now, but they actually pulled out, and then they were given the only license to operate an online gambling site since this act, and that was in Nevada. So I think they were out of London, and about 5 or 6 years after the passage of this act, they were actually given a license to operate in Nevada. So there are intrastate exceptions for this. Most notably, there is actually a fantasy sports exemption. So if you really want to start a Bitcoin gambling site, I suggest you make it a fantasy sports site. And there's also some Native American kind of provisions in there that you can look at. All right, the CFTC, the Commodity Futures Trade Commission, has not issued any Bitcoin-specific rulings, but they have issued a statement saying that they believe that Bitcoin is a commodity, or they believe it may be a commodity, which would come under their purview. So we're just kind of waiting to see whether or not they're actually going to make any rulings on Bitcoin futures. Since we are in California, I'm going to talk a little bit about AB 1326. AB 1326 is the equivalent of the New York Bit License in California. In some ways, it's not as extensive, but in other ways, it's actually worse. So I think that AB 1326's most disturbing provision is that they're going to require you to hold reserves in a manner that they see fit, and that does not include cryptocurrency. So if you owe your customers Bitcoin, but you have to hold your money in like state bonds or something else that they think you need to hold it in, the volatility of Bitcoin can quickly kind of put your business under a lot of strain. It's not as much of a problem this year, but it could be a problem in the past, and so that's kind of the most contentious point that I have with AB 1326. It passed the Assembly with a 68% yes vote, and it's now going into the Senate, so you can contact your representative about this.
I think the original New York Bit License proposal contained a similar provision, by the way, but
They took it out, exactly, yeah. The final bit license for New York does set a minimum amount, which is actually up to the department based on your operations, but they do not require that it's held in fiat, whereas this does. All right, I just have a couple of links, which I found pretty useful, and I will have this shared on the Slack.
So what about internationally? Would you recommend creating a company elsewhere, outside of the United States, or what's your opinion on that?
So if you're in the United States, and if you have customers in the United States, you're not going to really escape their jurisdiction by incorporating elsewhere. One of the things that I think people have said is good about going into Europe is that once you get a money transmitter in one country in Europe, you have a money transmitter for all of Europe. Here, it's on a state-by-state basis. If you're not dealing with fiat currency, if you're just dealing with Bitcoin and other crypto, you're going to need to register federally under FinCEN, but there's about 20 states that will actually let you operate without having a state license, most notably Texas. So Texas requires a bond of $300,000 to be a money transmitter in that state. But if you're not actually converting to US dollars or a foreign currency, if you're just crypto, then you can operate in that state free and clear. You don't need any license. And there's about 20 states that let you do that. It's really a state-by-state basis as to whether or not you're transmitting money according to their state law. So in California, you actually need to be going from person A to person B. So if I sell you cryptocurrency and you trade with somebody else and I'm not involved in that trade, and then somebody actually redeems cryptocurrency, but I'm just dealing one-on-one and one-on-one, then I'm not actually transmitting per California law. So that is something that has allowed a lot of people to operate without a California license. I have not seen a single Bitcoin company on the list of California licenses, including Coinbase, Ripple, all of those. They have not had a California license. That may be why they're pushing AB 1326. One thing that I think is really interesting in the New York bit license law is that the law actually states that you cannot skip out on getting your New York bit license by structuring your transactions in such a way that you're not being a custodian. So a lot of these multi-sig schemes and things like that people are using in their companies to avoid money transmitter laws, the New York bit license has said you still need a license with us to operate. The enforcement of that and what they actually do with that provision and the way it's kind of like phrased is a little bit ambiguous, so there is like some wiggle room in there, but applying for a New York bit license would actually be the best practice even if you're not a custodian and you're using like a multi-sig system. Any other questions? Okay.
Actually, the question about Electronic Fund Transfers Act, I've already asked you about this a little bit, but what makes you think that, like, what was the reason why you think that wallets would need to address it even if they're not FDIC insured?
So I think it's really the FTC's practice of applying those general laws to Bitcoin companies that would make it best practice. So because a lot of these cases say it's a cash equivalent and it should be treated as cash and things like that, I think that's why it's safer to kind of abide by those regulations. I mean, of course, it depends on your business case, but that's really the reason behind it, because the SEC will file based on their existing laws, and they have an argument that it's a cash equivalent. You have an argument that it's not a cash equivalent. But if they get a stay from a judge, you're out of business for the duration of that litigation.
Do you expect that Coinbase will start abiding by those laws, for example, then?
I think so.
EFTA too?
I think so, yeah. I mean, I can't really necessarily speak for them, but I do think that they will. Uh-huh.
Are you familiar with Open Bazaar?
Yes.
So what do you think the government can do about that?
So there's been public money disclosed, like, I guess, ownership of that, right? So if they think that this is related to black market and things like that, I could see a civil seizure of assets.
Okay, but they can seize the assets maybe, but let's say they start to try to take action after the software gets distributed, at which point, since it's decentralized, there's a bunch of software that's locally hosted on a bunch of different computers that are all over the place, and it's effectively decentralized, and it's not like Silk Road where you can just bust into their warehouse and shut down their servers.
Mm-hmm.
It's pretty much everywhere, so what do they do at that point?
Yeah, I mean, it's really just a cat and mouse game. I mean, civil forfeiture would kind of suck for the people who have invested quite a bit of money in that. And civil forfeiture, of course, occurs before a case is filed and things like that. You actually have to apply to get the money back. So that's kind of something that, depending on what Open Bazaar is used for, it can be very illegal. And if you hold it, right, if you have a node on your computer and they know you have a node on your computer, it would definitely be used as evidence of involvement in a black market. And, when it comes to involvement in these black markets, the police have a lot of leeway, especially when it's suspected, I guess, drug trafficking. So they can come in, they can take all the cash they find, they can take anything that they think would be stolen property. So they just kind of like seize all of that. And then you're left with the option of applying through the courts to get those things back if your hands are clean, or kind of letting them keep all of that stuff.
Right.
So that's, can they shut it down? No. Will they use it in raids to kind of take more and kind of associate more things with the black market? Probably.
So obviously, the regulatory structure is based on your current set of capabilities, right? I'm curious, as you guys are thinking about adding more functionality to these wallets, are you, like, what other laws or exposure do you guys see that you guys are going to have to start to deal with? Is there, you know?
So I think one of the hardest is going to be consumer privacy issues. And a lot of consumers actually demand more privacy than is legally required. In a lot of instances, especially people in Europe, they require a lot more privacy than people here in the US. And there's actually like a provision that you can apply for where you say, I'm abiding by the US laws and I'm in the United States, so please let me operate in Europe, even though my practices do not meet your privacy standards. And they do actually issue those kind of permits. So I think that that's probably going to be the most difficult one to navigate. Anything else? All right. Thank you very much.